Good morning. Before we begin our next case, I want to extend, on behalf of the court, a warm welcome to Judge Allegra Collins and her judicial writing class from Campbell Law School. Welcome. Our next case is State versus Norman, and we will hear from the appellant.
Thank you, Chief Justice Newby. My name is Michelle Goldman, and may it please the court, I represent Mr. Norman in this appeal. I'd like to reserve 6 minutes for rebuttal, if I may. This is a simple case controlled by one of the most straightforward concepts in Fourth Amendment jurisprudence, the scope of the implied license. According to the habits of our country, it is beyond reasonable dispute that no one is implicitly invited to linger on our driveways and peer into windows of cars parked there. That behavior, when it does occur, often results in a call to police or at least an alert to the neighborhood listserv. Officers' implicit right to be on our property without a warrant is defined by the same limits that apply to others who are uninvited. When officers pursue information on our property by engaging in behavior not allowed the general public, they are conducting a Fourth Amendment search. Under clear and unassailable Fourth Amendment precedent, they must have either a warrant or meet one of the carefully guarded exceptions to the warrant requirement. The majority below ignored the dispositive issue and created new exceptions to the warrant requirement that contradict controlling precedent. Judge Wood alone, in her dissent, understood that this case turns on whether Detective Diaz and his fellow officers acted within the scope of the implied license when, after no one answered their knock, they lingered on Mr. Norman's property to investigate the Durango. Because Judge Wood identified the issue and applied relevant and controlling precedent and reached the correct result, this court should simply reverse for the reasons given in Judge Wood's dissent. To demonstrate the correctness of Judge Wood's dissent, I intend to break my argument into 3 sections. First, I plan to address the scope of the implied license and discuss how the officers here exceeded that scope. Second, I will address why no exception to the warrant requirement applies. And finally, I will discuss why the Court of Appeals' reliance on the inevitable discovery doctrine to avoid the exclusionary rule must fail. Turning first to the implied license, it must be understood in the context of the Fourth Amendment's core principles. The home is the first among equals when it comes to the Fourth Amendment's protections from government intrusion. That protection extends with equal force to the curtilage, the area immediately surrounding and associated with the home. The warrant requirement is not a technicality.
The trial court's order doesn't tell us, it didn't seem to me anything to know clearly if the vehicle was in the curtilage. But there is a picture in the record, which we know the trial court also was aware of, that
Correct.
Seems to answer the question.
Correct.
Can we just look at the picture and say that is definitely the curtilage? It's right outside the front door is where the car is parked in the driveway, the Durango is.
I believe so. I don't believe there's ever been any dispute that this was in the curtilage. The officers, as the court has seen the picture, it's clear that the Durango was parked at the apex of the circular driveway, which was near the front door. So I don't think that there can be a serious issue about whether or not this search, Detective Diaz's subsequent search, occurred in the curtilage.
Right, so Collins versus Virginia would say that is completely settled. It appeared the Court of Appeals didn't really understand what Collins versus Virginia is saying, but my reading of it is, if that car is in the curtilage, which I think it is, then you cannot search it. You could, if that was the normal path that, as you said, anyone, the trick-or-treater or the neighborhood people could walk to your front door, you can look in the window.
I think certainly if Detective Diaz had seen something as he was walking to or from the front door, this would be a different case.
So the thing I found odd about the court's order is that it has language in there that I think is intended to confirm that the walk to the front door complied with the knock and talk doctrine, because it has this language that says that he used, I think it was like the door, yes, by the shortest route from his vehicle, he went to the door, which seems to be clearly for the knock and talk doctrine.
Correct.
But then on the way back, it doesn't say that anymore. Looking at the picture, you could see a shortest route from the door that would walk at least past the license plate, arguably, of the vehicle. But what is your reading of where the officer went and how, and whether or not that was also the shortest route back from the door to the edge of the property?
You know, I wouldn't, I would be more generous than that. I don't necessarily think that the officer has to take the shortest route, you know, but I think from this, what the officer did here clearly exceeds the scope, because he testified that when he left the front door, he didn't leave. He didn't walk back to his car by any route that any reasonably respectful citizen would have taken. He deviated from the permitted purpose of the implied license to investigate the Durango. And I just want to be clear, his search is a search of the curtilage. It's not necessarily, at that point anyway, a search of the Durango. And that's why the whole plain view issue arises.
But I guess what I was getting at, and you're right about that. That's fair. You don't. It may not be the shortest route, but it's got to be the route that's the natural one that you take to and from the door. And what's interesting here is there's even a finding, and there's certainly evidence in the record that the intent of the officer was to investigate the car, not to walk back out of the property.
Correct.
But if in doing that, you're still going on the path that would be permissible as your sort of exit route in a knock and talk, if your intent subjectively is, boy, I really want to get a look through the windows of the car, that's okay. And so what I'm trying to figure out is in the court's findings, because it does seem, I agree with you, that it does seem like what the officer did by saying he went around and then looking at the picture that we can see, you must have walked on the outer edge of that car, almost on the grass, and then come back around, which seems not the normal route of the implied license. So what's your view on that?
And I think it's important to remember the implied license has sort of three limits. One is durational. This is supposed to be quick. You go up, you knock promptly. If you're not invited to linger, you have to leave. So that's the durational limit. There's the locational limit, which is the front path or the path a reasonably respectful citizen would take. And then there's the purpose limit, which is to contact somebody at the front door, and if that doesn't work out, you have to leave. Here, Detective Diaz admitted, and the trial court found, that he exceeded not only the duration because he didn't leave, but also the purpose. He went and did the things he did for the purpose of investigating the Durango, not for the purpose of trying to contact the homeowner. And right there, I mean, that's sort of the exact same problem that we had in Jardines. There, the officers went to the front porch, which is an area that is recognized to be one that is within the limits of the implied license. But what they did while they were there demonstrated that they were acting outside the approved, permitted purpose. And it doesn't have to do with their subjective intent.
This sort of the struggle I have with that is that some of that is the officer's subjective intent, and that what really matters objectively is were you still within the implied license. And that's where I'm sort of struggling, because imagine that instead of it being this vehicle, it was like a really fancy car, like a Ferrari. You can imagine a lot of the people with the implied license walking up to the door, knocking, the salesman, and then on the way back down the driveway saying, man, that's a nice car, I'm really checking it out. But it's just right there in the driveway, you have to walk past it, and so there'd be nothing wrong. So how do we get from just, we know this is what the officer intended, to, and also it went beyond that, what anyone would have the implied license to do?
Well, I think if you think about what just generally we allow people to do, nobody would expect somebody to be on their property staring at their car and looking in its windows, peering in its windows. That would be outside anybody's reasonable expectation of what they were permitted implicitly to do.
I struggle a little bit with that because, like, if I owned a Ferrari and it was in my driveway, I would want people to stop and kind of, like,
But
do you see
that's
what I'm saying? That really, there's a little bit of a question about is just looking in the window as you're walking by it, and there's no findings about, how long, what was the officer doing, and that's what I'm struggling with a little bit here.
well, and I think, in terms of this is subjective intent, I think what it is we look at the behavior rather than the officer's subjective intent. And the behavior has to be to communicate with the homeowner. That is the permitted purpose that has been recognized. Well, where an individual might not mind if people come on and look at their Ferrari, that's not the customs of the country that have been approved of in Jardines versus Florida.
Had the officer parked at the first entrance to the driveway and walked by the car, would he have been permitted to look inside?
I think that if an officer glances over as he's walking and sees something in plain view, that's going to be a different case. In this case, that's not what happened. The officer testified that he stopped. He spent more than a minute investigating the license plate, and then he walked around the car to the driver's side, which is not an area he had passed before or he would have passed had he come up the other side of the driveway. As the court can see in the picture, the Durango was parked, the driver's side was very close to the edge of that side of the driveway, and any path that would have taken somebody from the street to the door would have passed across the other side of the Durango.
From the second entrance, right?
From
But
either entrance.
If we're talking the first entrance to the driveway, and the officer walks up the driveway, wouldn't he or she have to walk by the Durango?
Either way, you would walk by the Durango, one way by the front and one way by the rear, but neither way by the driver's side door. If the driver's side door was right next to the grass, and I'm just holding up the picture but the court can see that the wheels of the Durango were almost abutting the grassy area, and the normal path would have taken somebody either by the rear or the front of the Durango to the front door. And just to briefly respond to Justice Dietz's question to finish it, I think that the court in Jardines actually addressed that very issue of that kind of tension between a permissible purpose and an officer's subjective intent, because that was made. And at page 10 of the opinion, Justice Scalia says that that subjective intent can't invalidate otherwise lawful behavior, but where behavior reveals a purpose to conduct a search, which is not what anybody thinks they're licensed to do, that's where the problem is. It's not what the officer actually wants. He might go to the front door hoping that when the person opens the door, he'll smell marijuana or get consent to search. All those sort of subjective intent issues are not what invalidate the knock and talk.
Yeah, I guess the real question for me, that persuades me, and I also think there's a number of other things in the Court of Appeals opinion. I can ask your friend for the state about that. I can't wrap my head around it in terms of Fourth Amendment doctrine. But I think the real heart of this case for me is that you would see the license plate walking up to knock on the door. And I think it would certainly, the Supreme Court of the United States would say it would be okay on the way by for the officer to jot down, this is the license plate number, this vehicle I can see, make and model, and then discover, okay, wait a minute, we're looking for a vehicle that looks exactly like this. This has fake plates. And my question to you is that probable cause for the warrant? And the reason is, although this was not the theory of the Court of Appeals, we do have that independent doctrine, independent source doctrine case law that says if you had these things in the warrant application that were permissible, but then you also saw something, the cigarettes, the lottery tickets, that you shouldn't see, you do have to suppress that lottery ticket, the cigarettes, but you can use the other information to justify the warrant to search the car, and any incriminating evidence found that the officer didn't see in the impermissible, plain view look comes in. So can you focus on why, if I'm wrong about that, tell me why I'm wrong about that.
Okay, I think that this case cannot be saved by the independent source doctrine because under the independent source doctrine, the warrant, the ultimate warrant, has to be entirely independent of any unlawful activity. And while maybe the officer could note down a license plate while they're walking by, that's not what got him the warrant or got him the probable cause to get the warrant. It was what he saw in the windows. And that is a far more, and that just cannot be supported by sort of anything he could have done within the scope of the implied license. He walked up to the car and looked in. He was able to see the lottery ticket on the driver's side seat, on the driver's seat, which means he had a vantage point of looking down into the car. That's not the same as, inadvertently seeing something as you walk by. So that's one problem with it. But a bigger problem is Detective Diaz testified that he would not have sought the warrant had he not seen the incriminating evidence inside the Durango. And the independent source rule, as discussed in Murray versus the United States, says that it is not a warrant does not provide an independent source if procuring the warrant was a result of an unlawful search. And that's what happened here. So, and I think too, and then the other step is if you excise and re-examine, do you have enough? And if you excise and re-examine the warrant for the Durango here, you don't have enough. All you have is this passenger the day before, a passenger in a car, that's a loose association with the car, having a winning lottery ticket that was taken in a break and entry a week before. It's just not enough to tie the passenger to the crime or the passenger to the car to get the warrant. And Detective Diaz's discussion of the car and the fictitious plate was very generic. There was nothing in that tied it to the breaking and entering. So the only way he gets a warrant to look for evidence of the breaking and entering is by putting in that warrant application information that he observed unlawfully while he was conducting a warrantless search on Mr. Norman's property.
Can I ask you more specifically about that? As I understand it, you're arguing that, so I'm looking at page 25 of the record, the actual facts to establish probable cause, and it seems to me that paragraphs 13 and 14 are the two that we would have to excise.
Correct.
And your argument is that when you take those two out, the remainder of the affidavit doesn't justify the search warrant.
Absolutely.
Okay.
Absolutely. Yes, and
does the officer have to put aside the facts that the officer's aware of? For example, you would concede that a Dodge Durango missing a front bumper, black with black wheels, that's a bit of an unusual vehicle.
I think that's correct.
And the officer, at least from afar, thought he was able to read a license plate that came back that it was basically stolen. Can the officer have that in their mind as they're walking up to do the knock and talk?
First of all, I would want to say that there was no indication that the license plate was stolen, only that it did not belong to that car, that it was a fictitious
So it's a Maryland's license plate in North Carolina that goes back to a car rental place in Maryland. You don't think that raises a reasonable inference that that license plate has been taken from somewhere?
I would assume that when the officer ran the plate, it would have flagged it as stolen if it had been a stolen plate. But that aside, I don't think that, Mr. Norman is not contesting what the detective did in his approach to the house. I think his initial approach, I understand why he wanted to do it. I understand why he thought the car was suspicious to him and the plate raised suspicions and why he wanted to talk to somebody. But that didn't work out because nobody answered. And at that point, he had to leave under Florida versus Jardines. There were other things he could have done to continue investigating the case, but what he could not do is remain on the property and conduct a search of the curtilage without a warrant and without exigent circumstances. So the fact that he had ample justification for trying to do the knock and talk doesn't change the fact that he has to remain within the scope of that implied license to gather additional information or find another way to do it.
I may be just repeating Justice Earl's question here, but in the warrant application, so the trial court did make a finding that confirmed statement in the warrant application that coming up to the driveway of the property, the officer saw the license plate. We know the license plate that was a crime, and there was a license plate on that vehicle that did not match that vehicle.
Correct.
So just based on all the other information we just talked about the unique characteristics of the vehicle, that it's the one they're looking for, and then that information, your position is that's not enough for any magistrate to sign off on probable cause, that you had to also have the fact that the officer saw the lottery ticket and the cigarette, the things that through the window of the car.
So the warrant is for us to look for evidence of a specific crime, which is the break-in from Mr. Pete's convenience store or Mr. Pete's Market.
Right, and they know the car they're looking for from that break-in, right?
No, they don't. They only know the car that was associated with a woman passenger
Right, fair.
trying to cash a ticket a week later, which I would say is not enough to associate that car with the break-in, both because a passenger's association with a car is loose. It's not enough. What we would have to say is it's reasonable to infer that a passenger who possesses a winning lottery ticket, which is much like cash, a week after it's taken, provides a fair probability that evidence of the break-in will be found in the car. And that's a bridge too far.
So, I mean, I would frame it as, we know that someone using this vehicle had contraband. We then learn that the vehicle has a fake license plate, which you can certainly imagine that people engaged in criminal activity would do something like that to avoid being identified because they're engaged in some sort of criminal activity, like they have contraband, and that would get you the probable cause to say evidence of that illegal activity is in this vehicle that's has a fake license plate, which is the sort of thing that you could reasonably infer would be, okay, it's involved in the crime.
And if you look at what the warrant says about cars bearing fictitious license plates, it's very generic. It is people who commit crimes often use fictitious license plates or whatever. It does not in any way tie that car to the break-in at Mr. Pete's almost a week before in a different town. And the only thing that ties that car to that break-in is this female passenger a week later with something that is essentially cash. In looking through the warrant more carefully, it doesn't even say that she took the unredeemed ticket with her. So we don't even know that would be in it. And it's just too far of a leap to get to probable cause, a fair probability that this car will have evidence of a break-in that happened so long ago.
If we agree with you that it was impermissible for the officer to look through the window of the Durango, doesn't State v. McKinney tell us we ought to remand the case to the trial court to do a probable cause determination absent the tainted evidence?
I think State versus McKinney does say that, and that would be a perfectly acceptable result here. I think looking at the warrant and excising those paragraphs that contain the unlawfully obtained evidence, there's really no way this warrant survives. But should the court disagree with me, then yes, I believe that the appropriate approach would be to reverse the trial court's denial of the motion to suppress and remand for the court to conduct an excise and re-examine test on the warrant. If the court does not have any further questions, I'll reserve the rest of my time for rebuttal.
Thank you, counsel. We'll hear from the appellee.
Doesn't want to work for me. Good morning, and if it pleases the court, good morning, Mr. Chief Justice and Associate Justices. My name is Robert Brackett. I represent the state in this matter. And I have to disagree with Ms. Goldman somewhat in that the issue that this case brings to the court is not so much just whether or not a knock and talk was conducted within the implied license that all citizens are given, but whether or not, objectively, the search warrant in this case conferred probable cause to search the Durango for evidence of a crime. Considering that the question that's before this court is related to the objective reasonableness in the search warrant, this court's prior precedent also would direct that we give great deference to the reviewing magistrate in their determination of probable cause, and secondarily, also defer to the trial court and its findings of fact, because ultimately that's what was in front of the Court of Appeals. The Court of Appeals majority opinion does recognize that probable cause existed. It may not hit the language that would be perfect for my position in this case, but it does discuss objective factors that did exist even prior to Detective Diaz stepping on the property at Step Acres Mill Lane. He knew that an incredibly sophisticated breaking and entering occurred in Fletcher on December 12th. He knew that a very recognizable vehicle, missing a front bumper, a Durango with black rims, was used to attempt to pass a lottery ticket that was the substance of the breaking and entering at Mr. Pete's. And that attempt to pass was only 4 days after the breaking and entering, not a full week. Detective Diaz discovered that on February 16th. I'm sorry, on February 17th. The attempt to pass was on February 16th, and that was at 1 p.m. By 4 p.m., he had already received a search warrant to search the Durango. And the most important factor when we're considering whether a search warrant confers probable cause or not is not whether a person is involved in a crime, but whether the proper nexus has been created between evidence and location. And in this instance, in 24 hours, evidence being found in that Durango there's a fair probability that Detective Diaz could have found evidence in that Durango based purely on the information he had before he even approached the residence to knock on the front door. He knew that a very specific stolen item was possessed in that vehicle at 1 p.m. on February 16th. He also knew that that vehicle, that Durango, drove in a very specific direction. And in a very short period of time after Detective Diaz left Edneyville General Store, he found the Durango just off of US 64 on Step Acres Lane. Detective Diaz's testimony was it was a 5 to 10 minute drive. So we have temporal proximity in that the evidence was seen in a very recent time frame in the vehicle, and we have a locational proximity. The house, the residence where the vehicle was very close to the location where the stolen property had been possessed on video that Detective Diaz had seen. And then when he approaches the house as he's driving up the road, he sees that this vehicle has a tag that is, in his words and in the search warrant application, fictitious, but the state would argue that that could also be considered a stolen tag. Either way, in just recognizing that this tag did not belong to the Dodge Durango, rather it belonged to EAN Holdings, should have been on a Dodge Ram truck. Either way, that's a crime. If you look at it purely as a fictitious tag, it's a Class 3 misdemeanor. If you look at it as stolen property, it's a Class 1 misdemeanor. So before he even parked at the far end of the driveway, before Detective Diaz called for backup, the Court of Appeals correctly found that he did have probable cause to search that vehicle.
So why not just sit on the house at that point and get a search warrant?
That certainly could have been a cleaner way to do it, but Detective Diaz, in his testimony, said that he wanted to talk to the residents at that particular house just to see if they had any other information as to how they came about getting that particular ticket, that he was attempting to potentially look at gathering more information in his investigation at that moment shouldn't negate the fact that he already had this information in hand before he approached the residents.
So if the Durango had been over in the grass, parked away from the house, and the officer testified exactly what he testified here, he really wanted to take a look. That's the reason he's there. So he walks off the porch and then cuts across into the grass and looks around. Would you concede that that violates precedent from the Supreme Court of the United States, that's not part of the knock and talk?
That would certainly consist of traversing curtilage.
So the Court of
Outside
Appeals does not see this nuance, it seems to me. So at a minimum on that question, we would need to correct that misunderstanding with this opinion about what is this extent of what you can do in a knock and talk. Would you agree with that?
The Court of Appeals opinion in this case does not touch on that at all.
Well, it
as
seems
Your
to
Honor,
kind of discard Collins versus Virginia as if it's just irrelevant, that it's a car and you can go and search it, which is certainly not correct.
I'm not sure that I would agree with it entirely. The Collins versus Virginia case seems to have a little bit more of a substance to it when kind of analyzing an officer's actions within the curtilage. In that, first, Collins sort of balances out the protections of the curtilage versus the state of Virginia's argument that the Carroll Doctrine should permit them to search that vehicle. Second, in that case, an officer went on the property specifically to find evidence, which is not what Detective Diaz was doing at that residence. And so when the officer in Collins did actually lift up a tarp, he committed that trespass while trespassing, so to speak. So I see that there's a distinction there between that holding and what has occurred here.
But what about, the Court of Appeals also held that it would have been okay under some precedent, the court cited the McKinney case that we've already talked about, and then a Court of Appeals decision,
Yes, sir.
to linger on the property while another officer went to get a search warrant. Is that consistent with the Fourth Amendment?
If you classify what was done as lingering, it is not. And I will point
Well, but
to
the Court of Appeals, what it said, that's what it said, and that's a holding. So that would be the law in the state unless we corrected it. So is
and-
that the law under the Fourth Amendment?
that officers can linger.
That in a situation like this, the officers, knowing that they've got probable cause to get the warrant because of the license plate, could just linger next to the car in the driveway outside a home without a warrant while another officer drives to go get a warrant.
That fact scenario sounds similar to what this court has held in Grice. Because in the Grice case, officers were on the property conducting a knock and talk, and they saw evidence. And State versus Pyland, another Court of Appeals case, actually describes that action as lingering, which may
Isn't
need
the
to be
difference
cleaned up
that
as
it's
well.
only if you can see something that creates the exigency. So of course, if you see, you happen to see in the window in the knock and talk when no one answers the door, there's somebody flushing a bunch of powder down the toilet. That you may be able to go in the house at that point because there's an exigent circumstance. But in a scenario where you would need a warrant in order to search the property, you can't just say, well, I'm going to stay on the property until we show up with a warrant because, trick-or-treaters and everybody else, after they've knocked on your door, they have to leave. It seems to me that that's incompatible with Jardines. to say, well, you can just hang around because we know we're going to come back with a warrant eventually.
So I see that there's a distinction even in talking about what hanging around looks like in this instance. There's what Detective Diaz did, which is, I would say, less an investigation into the Durango and more a confirmation of what he already knew. And then there's what happened after Detective Diaz left. And what happened after Detective Diaz left is not part and parcel of the search warrant that's at issue here. However, there an exigency presented itself at that time. The remaining officers in that instance could have done something. They could have been a little bit more, I guess, discreet in their actions, and as if in maybe moving to secure the scene while Detective Diaz is writing the search warrant, moving themselves to the street 15 feet from the Durango, and then that part of the discussion is not being had. With Detective Diaz confirming, and I'll point to the trial court's findings of fact in the record, page 69. Detective Diaz, or the trial court paints Detective Diaz's motions as direct actions. There's a direct from his vehicle to the door. There's a direct from the vehicle to, or from the door to the rear of the vehicle, a direct from the rear of the vehicle to the driver's window, and then back to his vehicle. And lingering such that it was is no different than what occurred in Grice. Because in Grice, officers spent time, they don't testify, or at least the opinion doesn't reveal how much time the officers spent in that case on the phone with their captain, but they were on the phone, and in the Court of Appeals in Pyland did say lingered during that time period, but this court found that that action was constitutional. So I believe I would put to this court that there's no great distinction between this case and Grice in that respect. The only small distinction is when the call was placed. Diaz placed it, again, looking in the four corners of the document, Diaz placed that phone call to dispatch before he says he saw the lottery ticket and the pack of cigarettes on the dash of the vehicle. In testimony, he tried to clarify that, and he did say he couldn't recall exactly if he saw it as he walked, the pack of cigarettes on the dash as he walked up to the door or as he was leaving. But in either event, that's not, I wouldn't categorize that as looking into the window, seeing something on the dash, through the largest piece of glass that's on most vehicles, the windshield. It's as if we're asking, or it's as if the defense is asking that officers have blinders on as they walk to a front door and not look in the vehicle.
How do you answer the point that the defendant's counsel is arguing that they had to look down to see the lottery ticket in the seat as opposed to it being up on that dashboard? How do you respond?
I would say that that's nothing that any reasonable person might do in the curtilage of someone's residence if they're walking by a car. And this court in Grice specifically notes that officers can do, if a person exposing something in plain view runs that risk of what someone might see in their vehicle.
But do you agree that we can look at the photograph and,
Yes.
and that to get to the driver's side window, he was doing more than just walking past the car?
In the photograph, Your Honor, I'd say he walked from the rear of the vehicle, and the trial court's findings of fact echo this. He walked from the rear towards the front of the vehicle, which would have been by the driver's side, which was in the direction that Detective Diaz's vehicle was located.
Well, the trial court found as fact that Detective Diaz went to the window of the driver's side.
Yes.
Doesn't say he happened to pass by.
And I would say that there's certainly a rational inference that can be drawn that for Detective Diaz, who's parked on the far side of this driveway, to get from the rear of his vehicle, or the rear of the Durango to his vehicle, he would have to walk past the front driver's side of the vehicle. And in this
It really looks to
instance,
me like you would have to be standing on the grass in order to look in the actual driver's side.
I
And it would,
certainly,
again, I don't want the trick-or-treaters walking on my grass when they come. I have a pathway that goes to my front door, and I think that's the understanding of the implied license is what reasonable person would think is the way to go to knock on the door.
and while that picture, Defendant's Exhibit 2, is extremely illustrative of where the vehicle was in the driveway, the search warrant itself, if I may point the court to page 21 in the record. Now, admittedly, these photographs are not the clearest of quality, but the photograph on the left shows the Durango's positioning relative to the front door in relation to where Detective Diaz actually began his knock and talk. And if, in looking at that photograph, the driver's door is directly within the path he would have had to take to get to the door to even conduct a knock and talk.
I realize that the state's position is that there was probable cause even without what Detective Diaz saw when he looked in the vehicle. But if we do conclude that the look in the vehicle was outside the scope of the knock and talk, I have the same question for you that I had for your opposing counsel. Does McKinney tell us that the proper course is to remand for the trial court to make a determination in the first instance as to whether there was probable cause without the evidence that Detective Diaz saw when he looked in the vehicle?
And Justice Allen, I would echo Ms. Goldman's statement. McKinney does say if the court is going to excise and re-examine, generally the trial court is the best court to make that determination of assessing whether probable cause existed at that time. However,
Isn't that a question of law, though?
it can be a question of law, Your Honor, in as much as you have the fully developed record in front of you. We have the search warrant in front of this court such that it can look at that particular documentation and determine, as the Court of Appeals did, that even independent of that, probable cause still did exist. And really what we're looking at and what this court is tasked with is determining whether an error of law existed in that Court of Appeals opinion.
Right, and if the record is in fact fully developed, then the trial court is in no better position than us to make that determination.
Not at this point, no, Your Honor. So the way the search warrant is written, though McKinney generally says that excising and re-examining would require a trial court to determine whether or not probable cause existed. In this instance, the search warrant, the transcripts provide ample information for this court to determine whether or not probable cause existed outside of anything that assuming the court found that looking in a vehicle while approaching a house and while leaving a house is unconstitutional. This court's still in a position to be able to make that decision.
So we've talked a lot about independent source doctrine. What the Court of Appeals relied on was inevitable discovery. And I'm just going to summarize as I understand the Court of Appeals theory of inevitable discovery is that if you have probable cause such that if you went and got a warrant, you could force your way into someone's home and find a bunch of incriminating evidence. That if instead you walk up to the door and kick it in, and without a warrant search and find that same evidence, you can just introduce it because inevitable discovery says after you got the warrant, you would have found it anyway, which seems to me an absurd take on inevitable discovery. So are you defending that, or do you just not know what that's called?
In my brief, I will say that when the state was discussing inevitable discovery, it wasn't pointed towards the entirety of the evidence that was found against the defendant in this case. It was really pointed towards issues that both the dissent and defense raised, in that identity of the defendant may not have been discovered absent an officer looking at the VIN of the vehicle and then the VIN of the vehicle itself appearing on the search warrant. So in regard to that layer of inevitable discovery, the defendant's identity was going to be discovered, in fact, was discovered by an independent source, that being the landlord, who provided the names of both the defendant and Miss Atkinson, who lived at the residence, and provided the phone number to contact them. And
I
the
guess
search,
the point I was making is, suppose if the officers here had, in addition to walking around the driver's side, looking in there, seeing these things, also said, you know what, I remember something about an automobile exception where I don't even need a warrant here, so just went ahead and opened it up and found all the rest of the incriminating evidence. That you could not then argue, well, but look, if we excise the things they saw there, you still would have gotten the warrant, so it all comes in under inevitable discovery. I mean, you can see that that is not what the inevitable discovery doctrine is about.
certainly, and I understand
But
that
that is what the Court of Appeals seemed to think it was.
the, the Court of Appeals discussion on inevitable discovery doesn't seem to hit the mark as to what the heart of inevitable discovery truly is in that instance. I would also ask the court in this case to consider the fact that officers, when on the property conducting a knock and talk, there's been no case that breaks it down specifically into three separate segments: the approach, the knock, the leaving. The entirety of the process is judged on a objectively reasonable standard, and it's what a reasonable person could do while conducting this procedure. And in Jardine, Justice Scalia discusses the fact that a reasonable person looks like a peddler, a Girl Scout, a trick-or-treater that's walking onto the property. And in that instance, we don't ask officers to act perfectly. They just need to be bounded by what a reasonable person could do.
I think that's a good point. Some of the discussion seems to focus on, Officer Diaz needed to be 2 feet on the pavement at the entire time he was walking to and from. But Officer Borelli or Barrel was on the grass between the street and the Durango, right? And so it would seem that officer safety, those sorts of considerations would go into location as well.
And not only that, Your Honor, but the trial court's findings of fact also note that looking in the vehicle was done for officer safety. And I would put to the court that it would be unreasonable to ask officers to approach an unknown residence without at least verifying that no one is in a vehicle parked out front that could wish them harm.
Well, I would agree with you if it were Officer Barrel, right? He's standing out there as Diaz goes to the door. If had Officer Barrel looked in the vehicle, do you think we would have the same discussion about the impropriety of the conduct here?
The discussion would be different in as much as when Burrell was in the vehicle and looking in the vehicle, that was prior to or concomitant with Detective Diaz's knocking and the procedure at which he was at the front door. The discussion is only different in as much as Diaz also looked in the vehicle after he left the front porch.
Does the fact that Detective Diaz didn't look into the vehicle until after he went to the front door, does that undermine the officer safety argument?
If Detective Diaz were the only officer on scene, that would be a much more difficult proposition for the state to put forth. But Detective Diaz went across the street, waited at Turf Mountain Sod until backup came to the location, and actually approached with a second officer to the porch while leaving Detective Burrell and a third Henderson County Sheriff's deputy to, I guess, more or less look over the Durango to make sure that no one was in there that was intending to do them harm. So if it were a one officer situation, yes, that would not comport with that officer safety argument. But in this instance, the steps that were taken during the procedure did actually lead to at least the appearance that officer safety was a concern as Diaz was approaching the residence.
You've talked about a reasonable person standard. Here, this is not just a simple knock and talk. It's an officer that has specific information, that a license plate has either, well, it's clearly wrongly on a vehicle and perhaps has been stolen, both of which you've indicated are crimes. Um, You also have an officer who is aware of the uniqueness of this vehicle, given the information that he had previously received. What additional things, if any, could an officer do who has that information with regard to the vehicle?
Make sure I'm understanding. You're asking what else an officer could do in that situation?
If an officer knows that a license plate is stolen, is it reasonable for the officer to go to the VIN and say, well, I wonder whose car this really is, because clearly the license plate's on the wrong car?
Were the vehicle in a public location, certainly, that would be undisputed. That it's on the curtilage of this residence, the stolen or the fictitious tag on the vehicle lends itself to secondary analysis to whether the vehicle itself would be seized lawfully in the curtilage just based on that alone. The officer going up and looking at the VIN would seemingly fall more under the Collins type of analysis. Not that Collins would control as much, but it would look to see if there are more objective factors and what the officer did to actually discover the VIN. That makes sense. And I think that the court, this court in Grice can that can be instructive in that situation, in that the quote is that in Grice, no private interest in contraband in plain view of the driveway where any member of the public coming to the door might have seen it. And any member of the public in your scenario, Justice Newby, could have seen and might have seen the VIN. They might not have written it down. It might not have been significant to them, but that's a risk that's a person runs in leaving instrumentalities of a crime in plain view, even while it's on their curtilage. There's ample evidence, as I have noted, and I believe that the Court of Appeals has at least identified that probable cause existed in this case, especially when we provide deference to the magistrate in this case. The law of knock and talk, though the trial court's order does note that the Detective Diaz took the shortest route from his vehicle to the front door, does not require that. It requires a front path that a reasonable person would take to get to and then leave the residence. In this case, with the proximity of the vehicle to the front door, it would have been reasonable for any citizen to walk around the front bumper or the rear of this vehicle when going to the door to engage a resident in conversation. On that, the knock and talk portion of this search warrant, paragraphs, I believe, 13 and 14 of the search warrant, would stand as lawful actions that Detective Diaz took, because it's something that any of us could have done if we had approached that residence. With that, I would ask that the court affirm the trial court's denial of the motion to suppress the search warrant and the fruits of this warrant in this case. Thank you.
Thank you, counsel. Rebuttal.
Thank you, Your Honor. I think it's important to go back to those core Fourth Amendment principles that a warrantless search of a residence is presumptively unconstitutional. And starting from that place, we look at whether Detective Diaz's actions were justified under the knock and talk doctrine or any exception to the warrant requirement. The fact that Detective Diaz had information that inspired him to investigate, inspired him to go to the front door and knock, is not an exception to the warrant requirement. He needed probable cause and exigent circumstances to search the curtilage for additional information. It is not true that the knock and talk doctrine is sort of just kind of a reasonableness analysis generally. Justice Scalia gave us a very clear formula. It's a formula that our courts have followed in previous cases, and it's a formula that the United States Supreme Court addressed in Justice Gorsuch's statement in support of the denial of cert in Bovat versus Vermont, which is, we meant what we said in Jardines. There's no sort of grace period to hang out in an area like a driveway or a front porch to do other things. And in that case, the officers were on the driveway, peering through windows and seeing incriminating evidence, then leaving and getting a warrant, much like what happened here. Justice Gorsuch was appalled that the Vermont Supreme Court upheld the denial of the motion to suppress without even addressing Jardines in that case or understanding what it required. First, I also wanted to go back for a second to McKinney and what needs to happen in the event that certain paragraphs were included in the warrant that need to be excised. And that would be one potential option. But here, we don't even get to that because Detective Diaz testified that he would not have sought the warrant at all if he had not seen the incriminating evidence inside the Durango. And that's a full stop under Murray versus the United States. It cannot be an independent source following that testimony. I would like to also just touch on counsel's claim that Grice really controls here or is even instructive. Grice was not a knock and talk case. Grice addressed an issue of whether the seizure of items that were in plain view was permissible when the officer had to cross the curtilage to access them. In Grice, the defense did not challenge the knock and talk at all. So it wasn't an issue that the knock and talk was proper and that the officers saw the marijuana plants from a place they had a lawful right to be. It was only a plain view seizure case. I also just wanted to reiterate, it is so important in this case to note that the activity that occurred during and in response to the officer's unlawful continued presence on Mr. Norman's property cannot justify subsequent warrantless searches. Simply put, officers cannot create their own exigencies through their own unlawful conduct. That's what Kentucky versus King clearly says. And also in response to questions about whether the warrant, if we get to an exclude and re-examine place, whether there was enough information in the warrant to tie the Durango to the Mr. Pete's Market break-in. And I would just point this court to its own decision in State versus Lewis at 372, North Carolina 576 at 588. This court held that there wasn't enough evidence in the warrant to link the defendant in that case, who had been arrested on property, to the house that was being searched because there was no information more clearly tying his presence. And he was clearly associated with robberies, with armed robberies, but there was insufficient information in the warrant to tie him to the residence being searched. And that's the same problem here. In conclusion, Detective Diaz and his fellow officers unquestionably exceeded the bounds of their knock and talk by remaining on Mr. Norman's curtilage to engage in conduct not explicitly or implicitly permitted under the habits of our country.
Thank you, counsel. I believe your time has
Thank you, Your
expired.
Honor.
All rise.